You're facing a DWI charge and the DA offers to reduce it to obstructing a highway. At first, that sounds like a win. You avoid a DWI on your record, no jail, no probation, no interlock device. But here's what most people don't realize. Even that lesser charge can still wreck your record, your job prospects, and your future. I'm Barret Dye. I'm a criminal defense attorney here in Texas, and I've handled hundreds of DWI cases just like this. In this video, I'll walk you through exactly what you give up when you take that plea, and when it's actually a smart move to say yes, so you can make the right call for your case, protect your future, and avoid a deal that quietly costs you more than just a conviction. What obstruction of a highway really is. So let's start with the basics, because the name of this charge throws people off. Obstruction of a highway. It's a real criminal offense here in Texas. The simple version is this. The state claims you blocked, interfered, or created a safety issue on a roadway or a passageway. And when this comes up in a DWI case, the prosecutor is usually using it as a landing spot. It's a way to still get a conviction without having to prove the hardest part of a DWI case, that is, intoxication, and proving it beyond a reasonable doubt. That's why this deal exists. Not because the state is doing you a favor, it's because they're managing the risk. Why the DA offers this deal. Here's what I want you to understand. DWI cases are not always a slam dunk. Sometimes the stop is shaky. Sometimes the field sobriety tests look worse on video than they sounded in the police report. Sometimes the officer overstates things. Sometimes the breath or blood evidence has issues or the timing doesn't line up cleanly. And if the prosecutor feels even a little uncertainty, they have a choice. They can roll the dice at trial and risk losing the DWI completely, or they can offer you a deal that still ends in a conviction. And that's obstruction. So when you get this offer, it often means one thing. There's something in your case that makes the state nervous. The big misunderstanding. Now let's address what your hook called out, because this is where people get burned. A lot of folks hear reduced charge, and they mentally translate that to, okay, so I'm basically in the clear. But you're not. Obstruction is still a criminal offense. It can still show up on background checks. It can still create problems with jobs, apartments, and professional licensing. And depending on how your case is resolved, it can still stick to your record longer than you think. So the right mindset is not, is this better than DWI? The right mindset is, what does this plea actually cost me? DWI versus obstruction, what actually changes? Here's the straight answer. A DWI conviction carries a unique label that follows people for a long time. It's a signal to employers and licensing boards that a lot of people judge instantly, whether that's fair or not. Obstruction usually doesn't hit people the same way. It's still a conviction, but it doesn't come up with the same automatic assumptions. That difference matters in the real world. And there's another major difference people don't often think about. If you pick up another DWI later, a DWI conviction today can change how that future case is punished. An obstruction plea typically doesn't operate the same way as a prior DWI conviction. So, for some people, taking obstruction now is a way to avoid setting a trap for their future. What you actually give up when you take the plea. Now let's get to what you asked for in the hook, what you give up. First, you give up leverage. Once you accept the deal, there's no more fighting about the stop, the tests, the officer's mistakes, or whether the state can actually prove intoxication. You are choosing certainty over the chance of a full dismissal or not guilty. Second, you give up the ability to use the state's weaknesses to your advantage. And that matters, because if the state is offering obstruction, there may be weaknesses worth pushing on. Third, you give up the option of being completely clean. Even if the charge feels lesser, it's still a criminal case outcome. And if your job is sensitive, if your licensing board is strict, or if your background checks are intense, that can still matter. So when people tell me, I just want it reduced, my next question is always, reduced to what and for how long? The part that quietly hurts people. Let me give you the hidden issue that blindsides people. A lot of damage doesn't come from what happens in court. It comes from what happens later when somebody runs your name. Employers don't always care that it's not DWI. They care that it's a recent criminal case. Apartment complexes don't always care about the details. They care that you have a record. And some professional boards care about character and conduct in a broad way, not just the specific labels. So yes, obstruction can be a smart move, but it's not automatically harmless. When it's smart to say yes. So when is it actually a smart move to take this plea? It's usually smart when the downsides of losing a DWI trial is catastrophic for you. If a DWI conviction threatens your career, your license, your immigration situation, or your long-term plans, then avoiding that label can be a major win. It's also smart when the evidence is good enough for the state to convict, but not bad enough that you feel confident gambling your future on a trial. In other words, when the case is a coin flip and you can't afford tails, certainty has value. And finally, it can be smart if you're in a position where you can later clean up the record, depending on your eligibility and the final outcome. That's where the long-term strategy comes in, when you should seriously consider fighting. On the other hand, if your case has real legal problems, like a bad stop, bad testing, weak evidence, or officer mistakes, then taking the first plea offer can be leaving a full win on the table. And I've seen it go both ways. I've had clients where obstruction was the smartest path to protect their career. And I've also had clients where we pushed, exposed the weak points, and the case fell apart. So if the state is already offering a reduction, that's a sign to slow down, not rush. How to make the right call. Here's the decision framework I use with clients. First, we identify what the state can actually prove and what they can't. Second, we define your real-life stakes because that's what should drive the strategy. Third, we look at the full picture, criminal case, license consequences, background checks, everything. And then we choose the path that gives you the best long-term outcome, not just the easiest short-term exit. Quick recap. If the DA offers to reduce your Texas DWI to obstruction of a highway, it usually means the state sees some risk in proving the DWI. Obstruction is still a criminal offense, and it can still damage your record in your future if you treat it like a free pass. But for the right person, in the right case, it can be the smartest move you can make because it avoids the DWI label and protects you from bigger long-term consequences. Now, if your DWI involves a breath or blood test at or above 0.15, the stakes jump fast and the playbook changes. In my next video, I break down what DWI over 0.15 means in Texas, what the state has to prove, and how you fight that kind of case the right way. Go watch DWI over 0.15 in Texas, what you must know to fight your case, and I'll see you there.